Hi there, this is Jackie Werns with Education Civil Rights Solutions, and I am excited to talk to you today about the 2024 Title IX rule, which is finally here, you guys. It's finally here. I feel like we've been waiting for this thing forever, and now it came into our lives at 5 o'clock Eastern on Friday morning of last week on the same day as Taylor Swift dropped her newest double album, The Tortured Poet Department. And so I couldn't resist making a Taylor Swift themed presentation for today. So you're going to notice that there's a lot of language from Taylor Swift's new album in the mix today, but I just thought, let's make it a little bit fun, right? So first of all, I wanted to give a little bit of background, I guess, or an update for I've had a lot of people asking me, Jackie, what the heck is going on? Where do you work? And so I just wanted to give a little bit of insight on that. Thanks to everyone who's reached out. I actually left the law firm life in March, and I'm very excited to be in a full-time role with the University of Idaho as their acting director of civil rights and investigations. So that is my 9 to 5. It's absolutely incredible. For those of you who are on the administrative side, it has just been such a pleasure to actually be in there doing the work. And I was in that role on an interim basis through my previous law firm from about June, late June of last year. So I had really been given the opportunity to see what it was all about in a temporary way. And at the end of the year last year, we just all decided that it was a good fit. So I'm still located in Dallas, Texas, but I am sort of in a hybrid role. I'm spending a fair bit of time out there in Idaho, primarily in Moscow, where the main campus of the university is. So that's my main gig. Now, I am also, as you probably know, a huge passionate proponent of civil rights in K-12 schools. And so I do a fair bit of consulting work with K-12 school districts. I do expert witness work with your lawyers, your main lawyers, because I don't have time to be your primary lawyer, but I'm often there when they need an expert to either help with a case or to help with a lawsuit if it's come to that. So in order to keep doing that work on a limited basis on the consulting side, I have started a company, ECR Solutions, Education Civil Rights Solutions, and I'm very excited about the opportunity to just try out this different angle of work. But so I am here because you know I can't keep myself out of this conversation. And I just have so many thoughts to share about the new regulations. So let's jump in and talk about what we're going to be looking at today. So first of all, we're going to say so long to the 2020 rules, talk a little bit about how we got here. And then we're going to talk about you can fix this. No, really, you can. I really believe that this is actually a good rule change for our institutions. And so I'm really actually quite excited about the changes we're going to be able to make and the streamlining we're going to be able to do. So we're going to talk about that, and then we'll talk about the rules themselves. And I really want to go into this with the mindset of who's afraid of some little old rules? Nobody's afraid, right? This is totally fine. We've got this. We can do this. And then I'll finish up with a little bit of the prophecy of what's going to come next and what we should all be thinking of and doing as we are getting these rules in place for the implementation deadline. So to start out with, so long 2020 rules, and I want to give you some numbers to think through here. Thinking about these numbers, that we went 666 days from the proposal of the rules on June 23rd, 2022 to the final rule on April 19th, 2024. And you can read into that whatever you want. I just did the math. So 666 days, it was a long wait from the proposed rule. But when you look at what the Department of Education did with that time, I can actually see that they were really putting a lot of effort in to taking comments extremely seriously and making changes. So Kudos to them. I still wish we could have got it a little bit earlier, but I can absolutely see that this is not a situation where they just spent that time trying to make excuses for the rule that they had proposed. Rather, they made a lot of updates, very substantive ones that I think make the rule better. So good job to the Department of Education. I know that this is hard work for them, and we are strong critics. I am, as a former US Department of Education employee myself, I am probably one of the biggest critics, but I just want to say good job, way to go on these rules as far as at least taking the comments that were given and making changes where it was reasonable to do so. They gave us 104 days to implement the rule. That's good. In 2020, we had 90 days and there was a global pandemic. So again, getting back to this theme of we can do this, we can fix this, we really can. We have 104 days to do this work. And this isn't starting from scratch the way that it was in 2020. We already know so much about the foundations here. And so this is just going to be us making tweaks and changes in order to get our program in line. We lived with the 2020 Title IX rules, or I guess I should say we will have lived with the 2020 Title IX rules for 1,447 days, 3 years, 11 months, and 17 days we lived with those rules. That's kind of sad in the sense that, we would hope that federal regulations would last a little longer than that, but really, we got the 4 years that the new administration has been basically in the office since since the rules went into effect, and now they've changed it. That's something to think about, obviously. Potentially, if there is a change in the administration again after the election this fall, we could be looking at a situation where we're only living with these current rules for 3 years or 4 years. So we're going to settle into these rules, but we're going to do so with the understanding that we now know this isn't the kind of permanence that maybe we were accustomed to under the previous civil rights regime that existed before 2020. And hey, I can tell you this much. They got it in at least 1 day shy of the Congressional Review Act deadline. I know some smart people who work in Washington, D.C., and I trust them. And so I ask, because I got to tell you, I still haven't figured out how to fully calculate the deadline. But remember, what this means is that if they make this deadline, then if there is a new administration that comes in the fall, and if the Congress is to become controlled by Republicans, or if Republicans were to have enough Democrat support for getting rid of these rules, they would be able to come in on essentially day one and just wipe the slate clean as if these rules never existed. And that would be after we already implemented them. So I'm really glad that they made this deadline and that these rules are at least here to stay until a new administration comes in and goes through a new notice of proposed rulemaking process and goes through the whole comment period and response to the comments, which again took us 666 days this time. So these rules are here to stay mostly. I'm going to talk a little bit about lawsuits in a minute. All right, so now that we have said so long to the 2020 rules, let's talk about you can fix this. No, really, you can. Here's my advice to you. Don't get too caught up in the academic discussion. There are a lot of really nerdy people out there. I'm one of them who set their alarms for, in my case, 4 a.m. Central on Friday morning and woke up and feverishly refreshed that page until everything came up and then started reading. And we've been talking to each other over the weekend. We have been just getting into it. I honestly felt like it was a little bit like Christmas morning, which is kind of a sad thing for me. At least I had the new Taylor Swift album to keep me busy in the background. But those of us who are those big nerds, we are going to have some really intense academic discussions about these rules. But if you're a practitioner out there and your job is just to get your educational institution into shape for the August 1st implementation deadline, then you need to just really focus on getting these rules in place in a practical manner. So how can you do that? Well, first of all, there is some benefit to understanding changes between particularly the proposed and the final rule. And I've created a red line that you can find on my website. The link is educationcivilrights.com. And if you go there, you can click on the new Title IX rules page, and there's a red line. And I think it can be really useful to see where they made changes, where they beefed things up or drew things back a little. So don't hesitate to take a look at that, because I do think that can be helpful. There's also some really cool side-by-side things out there. I know Tix has got one. It's a little too high tech for me. I'm kind of old school, so I printed out my red line, and I have it in my little binder here so that I can go and look at it when I want to see what are the changes that they made between the proposed rules and the final rule. But really, honestly, just if you can even stay away from that and just really focus on the process and using the rules as finalized for your path forward. So in order to do that, you are going to have to navigate the final rule itself. And I'm making a disaster here because I want to show those of you who are seeing this on video. This is the size of this baby. It is gigantic. It is so big. It is almost 1,600 pages long, and there's a lot in there. I'm not going to lie, I haven't read every bit of it yet. Nope, have not. It's only been since Friday. And I'm one person, guys. Like, I don't have a company. I don't have marketing people. This is my kind of, thing I have to do on the weekends and early morning before I go to my real job. So I haven't gotten through all of it myself. But if you just skip to the end and go to just the rules themselves, and you can find on my website that I've actually created a PDF that is just the rules, not the preamble. So that's about 50-ish pages or so. And that's really what I would focus on, because that is going to include what the requirements are going forward. And when I say focus on the process, from my review of this, the biggest thing that you need to do right away is to figure out what your process is going to look like. And so in order to do that, we'll talk about this more in a second, you're going to need to look at the two new grievance process paths that are in the new rule. One of them is 106.45. That applies to all cases. And then you're going to add in 106.46 only if you are a higher education institution and only in cases involving sex-based harassment with a student as either party or as one party. It could be one party out of 50. But if you've got a student involved, then you have to fold in the requirements of 106.46. So I would really start there by figuring out what your process is going to look like and start working on your policy and your grievance procedure. The grievance procedure actually does have to specifically be in writing now under these new rules. So that is new. I know a lot of people had grievance procedures that they kind of had in the background, but I worked with a lot of especially K-12 districts that really just had their policy. And so you're going to have a procedure. If you're terrified about that, don't be. There are going to be so many resources out there available to help you. I'm going to have resources available to help you. So please check out my page, and there are going to be other resources. You are not going to have to do this alone, but you do need to start thinking about what you want it to look like at your institution, because there is a lot more customization allowed under these rules than there were under the 2020 rules. Well, let's talk about what those rules look like. And again, I can't go through them all with you. I don't want to keep you here for hours. So we're going to really focus on just a few key things here, but I really do want to go into this with the mentality of the rules are saying to us, who's afraid of little old me? These are just some regulations, okay? I got to be honest with you, in my role in higher education now, running a civil rights department for a university, I'm honestly a lot more nervous about the 504 web accessibility rules than I am about these. Now, maybe that's because I just feel like I know these so well, but regardless, these are just another rule and they're not terrifying. So we are going to be able to do this. So who's afraid of this little old rule? Well, what does this little old rule say? To start out with, I want to address sort of the elephant in the room, which is sexual orientation and gender identity, and recognize that they really have rewritten the book in some ways here when it comes to Title IX, because the 2024 Title IX rule, the new rule, explicitly says for the first time that harassment and discrimination based on sexual orientation and gender identity are based on sex under Title IX. And this has been an open question since the Supreme Court decided the Bostock case, which was a Title VII case that held that you couldn't fire someone, terminate someone based on their sexual orientation or gender identity in the workplace. And so there was a big battle between, within the Department of Education, both the Trump administration as it went out, the Biden administration as it came in, and there's been a battle in the courts where people are arguing should or should it not cover sexual orientation and gender identity. This is obviously it's a big change. The big thing you need to understand, though, is that we've already been addressing harassment based on sexual orientation and gender identity under Title IX. And a part of that is if you work with me, because even the Trump administration acknowledged begrudgingly, potentially on the way out the door, that they interpreted in OCR the Bostock decision to apply to Title IX, at least to the extent of bullying harassment. So this is not news, okay? The big issue that we're dealing with in applying this standard is with respect to pronouns and with respect to other things that could be free speech by one student or by an employee against another another individual whose gender identity doesn't match the pronouns or other information that people may have about what was assigned to them at birth. And the department really punted in the preamble when it came to pronouns, basically just saying it's a case-by-case consideration. I do know that during the press conference that they held on Thursday afternoon, that a reporter asked a question of the Department of Education representative about pronouns and received the answer that it could be harassment in some cases. I feel pretty confident saying that if the only thing that has been alleged is that, for example, on one occasion, someone used a person's pronoun or dead named a person, used their name that they no longer use because they've transitioned, that wouldn't rise to the level of harassment. But where we're really going to have to figure things out is if it's happening frequently, what is the context it's happening with them? Because what the department has recognized is that they will understand at least some instances of use of pronouns or names to be harassment. Also, big issue in these new rules is bathrooms and locker rooms. The 2024 Title IX rule clarifies that a recipient can't separate or treat any person differently based on sex in a manner that subjects them to more than de minimis harm, except in certain limited specified circumstances permitted by Title IX. Now, important thing to understand is that one of those specific circumstances is athletics teams, okay, and also housing. So if you have gender-specific athletic teams, gender-specific dorms, the department is recognizing that, at least for now, that's not going to be analyzed under this rule. We're going to analyze that using something else, and frankly, we have no idea what that is because they didn't finalize their athletics rule. What we're talking about here, and where this is really going to be important, is with respect to bathrooms and locker rooms. And what the department said is that it's not presumptively unlawful sex discrimination to use sex separation in bathrooms and locker rooms or other circumstances, but it imposes more than de minimis injury on a protected individual when it denies a transgender student access to a sex-separate facility or activity consistent with that student's gender identity. That's a lot of words, but it's important. In the preamble to this rule, the Department of Education has signaled to us what its position is with respect to bathrooms and locker rooms, and that is that it is more than a de minimis injury and therefore prohibited by Title IX to use rules to keep an individual out of their restroom that matches their gender identity. That's what they're saying here. Now, let me be very clear to riff on the titles of one of my favorite movies. There will be lawsuits, okay? There will be lawsuits. If they haven't already been filed this morning, they will be filed. And I'm attributing this quote to someone famous and smart. I don't know who says it or who knows it, but I feel incredibly confident that states attorney generals, independent groups, they are going to come in and they are going to file lawsuits about this interpretation. We're just going to have to see where things end up as far as what the courts say about both. Are they going to defer to the Department of Education? If you are an administrative law nerd out there, you may know that Chevron deference, which is deference to administrative agencies, is a little bit on the chopping block right now. So are they even going to defer to the Department of Education's interpretation of Title IX to cover gender identity and sexual orientation? And even if they do, are they going to find that this was a reasonable interpretation that the Department of Education has put in place? Courts could just say that they don't believe that Title IX covers gender identity and sexual orientation. That is not the majority view in courts right now, but could it happen in our current US Supreme Court? I'm not going to say no, it could. So we are going to have to just wait and see on this. I don't really think this has changed the game all that much. I think we've all known this was the approach of the Department of Education, but obviously this tees up a battle. It's going to come. So we're going to see what happens. In the meantime, this is an area where having an expert who really knows Title IX and knows the nuances really well, if you receive a request about bathrooms, locker rooms, definitely keep that in mind. And note too that the language they use in this, it's the no person language. So even though I'm quoting from parts of the preamble that refer to students, the preamble says that this law or this rule, as it's been interpreted, applies to everyone who's a part of your community. So if you get a request by an employee to use restrooms or locker rooms or pronouns or anything like that, that's going to be a place where you're going to want to make sure you're leaning very hard on your experts. Don't do it alone. All right, so let's talk about now everything else besides that very big change. Obviously, a very big change, but there's a lot of big changes here. So I'm going to run through them. This is going to feel like speed dating right now. But again, the goal here, just acclimate yourself to this because we're going to walk through some of these. And then also you're going to have lots of time to get used to these. I've already signed up for so many webinars over the next 2 weeks. So go to them all and learn, because we are going to become familiar with these through repetition. All right, let's jump in. So first of all, big change. We know that under the old rules, we had a grievance process that we used for Title IX sexual harassment. Now the rules have expanded the grievance process to say you must use it for all sex-based discrimination. So that includes instances where someone is alleged to have treated someone differently based on sex, where there's maybe a neutral policy, but it's been alleged to have a negative impact on people based on sex, and then harassment, and also retaliation. If someone is engaging in the process to either complain about or respond to sex-based discrimination and they receive some adverse action in response, including peer retaliation that is defined in these regs for the first time. So if they receive that retaliation, you must use this grievance process in order to address it. That's going to be a lot more stuff. We're going to talk about some other things that can make a lot more stuff, but the good news is we'll talk about they have pared down the process a fair bit. So I think on balance, we're probably going to still come out ahead as far as what we must do in response to a complaint. I think we're still going to come out ahead as far as what that looks like. They've also changed the lingo on us in the rule. So instead of calling harassment sexual harassment, they're calling it sex-based harassment. And that's really just to highlight that not all harassment that is sex-based harassment is sexual in nature. Conduct that involves, I always like to say, if it involves a private body part, it's probably based on sex, okay? If it involves a penis, if it involves a vagina, it is probably based on sex, meaning it is sex-based. That doesn't mean it's necessarily discrimination or harassment, but it's probably based on sex. So that doesn't matter if it's sexual. It could just be one, sixth grade boy making fun of another sixth grade boy's size of their penis. But that would be sex-based harassment, even though it's not sexual. It's also intended to make sure that we know that things like stereotypes based on gender, what people expect from someone to do as a member of a particular gender, that can be sex-based harassment, that sexual orientation and gender identity harassment can be sex-based. So the idea here, it didn't actually change anything as far as the law, but it's just meant to highlight that we're not just talking about sexual things here, things that are romantic or intimate in nature. Big change we'll talk about on the next slide a little bit more is that conduct now is covered as hostile environment sexual harassment under Title IX if it is severe or pervasive unwelcome conduct based on sex that limits or denies someone's ability to access your education program or activity. That is a lower bar. We're going to talk about that in a second, so I'm going to skip on for now because there's a lot of stuff on this topic. The rules allow former participants in your education program or activity and volunteers to file complaints. So the real key for an individual who is filing a complaint, who's a student or an employee, is were they a student or employee at the time that the alleged conduct happened, not are they one of those things at the time that they are filing the complaint. You can do informal resolution now without having a complaint on file. For those of us out there doing this work, I know you know this is good. Informal resolution is good. I'm going to do a whole separate thing, hopefully soon. But, again, I've got to do these on the weekends. So, probably in the next few weeks on what the informal resolution rules look like under this regulation. But the good news is that you're going to be able to use it more frequently, and that's going to be good for us and good for our parties. Something that's not good for us is that the rules say that oral complaints count as complaints. So under the 2020 rules, we could require that there be a written complaint, which the complainant was required to sign. That is now gone, and it is sufficient for a complainant to say to someone who has responsibility to report it to the Title IX coordinator, I would like you to address this using your grievance process. And they don't have to use those magic words. They can say it in the ways that are much more normal. Hey, I really want the university to do something about this, or can't the high school do something about this conduct that happened to me? But oral is sufficient. So we'll talk a little bit about training requirements, but man, y'all, I'm going to do a whole separate thing on training, because you are going to really need to get in there and train your individuals who have a responsibility to report to the Title IX coordinator on what they need to report. And that is especially true for K-12. We'll talk about this in a little bit, but you guys, you're still on the hook. Every employee's knowledge is still attributed to you as an institution. Another big change, I mentioned it before, is those two grievance processes under Title IX. So we've got one process that is for in post-secondary education, sex-based harassment involving a student, and then you've got one for everything else. I just talked about training. There's lots of training. You need to train your Title IX team on certain things, all employees on certain things, confidential employees on certain things. Again, I'll bring more to you on that later. There is a requirement in the rules that for K-12 school districts that you have to collaborate with a member or members of a disabled student's Section 504 team or IEP team. This was such a big win. When I was at Thompson and Horton, wrote a comment in response to the proposed rules on behalf of a coalition of K-12 school districts from across the country. And one of the things we pointed out was that the proposed rules had suggested that the Title IX coordinator should coordinate with the whole Section 504 or IEP team in order to go through the Title IX process. That would have been a disaster. If any of you know anything about practicing on the special education side and disability side in K-12 schools, the team that's a whole process. You got notice, everybody's got to be there, you got to have certain members. So now they've changed it to where that collaboration can be at the discretion of the Title IX coordinator. with a member. So, the director of special education, for example, or with the whole team if it's warranted. But in many cases, we're going to be able to collaborate on a much more reasonable basis. But that's a good change. And hopefully we've all been doing that anyway. There are a lot of requirements for pregnant and parenting students. I'm not even going to really touch on those today because, man, there's just not time. But I will come back and give you thoughts on pregnancy and parenting separately. But it's a lot. It's a lot. And especially for K-12 schools, I think this is going to be something really new. And so it's going to be something that you need to focus a lot of attention on over the summer. There are also a lot of proactive prevention requirements that are on the Title IX coordinator. I know I'm looking at those really carefully as a Title IX coordinator myself to understand what kinds of data review do I need to be doing? What do I need to do to address any barriers to reporting that might exist in my community? So there's a lot there that, again, I will come and talk to you about separately. And I'm sure that all the other smarty pants out there that are thinking this through are going to talk to you about that as well. One thing that I just scratched my head at, and honestly, there are so many things in the proposed rule, and we did the best we could with comments. But one thing that I think kind of flew under the radar is that there's this provision, and I've cited it. It's 106.45 D4 little I. And it seems to suggest that if a formal complaint is filed, so if someone says those words of, I want you to, investigate this, even if the conduct alleged is not Title IX, even if eventually the Title IX coordinator evaluates it and determines that it's not Title IX, the regulations suggest that we would be required to provide supportive measures to the parties. And that's a little concerning to me, not because I think it is a bad idea. For those of you who've done training with me, I like to talk about how my family, we're a big dog family. And if one of my dogs passed away, it would be really hard for my kids. And I would hope that their school would support them through that process. Unfortunately, that did happen to us earlier this year. And they did because they're good people. They didn't do it because a law required them to do it, but they also didn't have their Title IX coordinator do it. And they didn't have their Title IX coordinator coordinate it. And that's normal because, if you're a Title IX coordinator, we're just one person. And frankly, we're often operating on very limited budgets compared to the work that we're required to do. So requiring Title IX coordinators to supervise, implement, oversee supportive measures, even if a complaint is determined not to trigger Title IX, that would be a big lift. So that's going to definitely be a question that the open center is going to get from me in the next couple of days, just to try to clarify that. All right, let's talk a little bit more about the whole severe or pervasive. I am so glad I'm not going to have to hear SPOO anymore. I couldn't handle that. You guys know I didn't call it that. I always called it hostile environment, sexual harassment, because I didn't like that. But we don't have to say it anymore. I think some people are calling this SORP. Some people are calling it SOP. I think severe or pervasive is pretty short, so I'm probably just going to say that. But what are we talking about here? Well, when something has to be severe and pervasive or persistent, that means that it has to both be somewhat shocking in the context. So I've got, for those of you who see in the video here, this shocked cat, something that is just like really shocking to the conscience, not your normal bad behavior, crass behavior. If it's pervasive, we're usually talking about that it's repeated or it's widespread. So under the current 2020 rules, we were able to just reject from the Title IX process anything that didn't meet both of those things. Now we will have to address under the Title IX process anything that meets one of those things if it is unwelcome conduct based on sex, and if it has an impact, really just a very limited impact on a person's access to the education program or activity. So what are we potentially talking about here from a practical standpoint? Well, first of all, slurs is what I think of when I think of conduct that is severe, that we might not have addressed before, but that we might address now under the Title IX process, even if it's something that only happens once or maybe a couple of times, and we wouldn't be willing to say that it is pervasive. I know that in the context of race, that the Department of Education has pretty clearly taken the perspective that the N word is sufficiently severe that if it's said to a person who is African American, that would be something that would need to be treated as harassment. And that makes sense. It's unclear what other words would meet that standard. Would someone saying the F word, which is a slur for someone who is gay, would that be adequately severe? Maybe. I think maybe. What about calling a female the S word that deals with calling someone promiscuous? I don't know. There's an argument. I mean, gosh, that word is so unfortunately pervasive that, is it severe if someone says it only once? But we're going to have to think through all of that. I think that's going to be really the clear place where this ups the ante for the number of cases that we're dealing with as just severe. Obviously, certain types of touching and physical conduct would be severe too, even if not pervasive, but we're already covering that stuff as sexual assault, for example, or maybe domestic violence or dating violence or stalking. Pervasive is probably going to bring in a lot more than severe. So right now, it has to be pretty serious, the conduct, to fall under Title IX, even if it's happening all the time. But I have seen tons of cases in my time where the conduct might be relatively minor, quote unquote. It might be, joking or things that wouldn't have met the standard of severe under the current interpretation. But if it happens enough, if it's repeated, or if it's widespread, if it is somehow sent out on the internet or shared in some way that makes it catch fire, then I think we're going to have to use the Title IX process to address it if it's sex-based. So this is going to be a lot. The good news is that we've got two processes that we're going to be using under these rules. And it's laid out here as path 1 and path 2. You're going to see I don't really actually analyze it this way, but I think it's just easy to see it this way and think about it this way initially. That path 1 is for complaints of sex-based harassment involving student complainants or student respondents at post-secondary institutions, higher education. And this process looks a lot more like the 2020 Title IX rule process, with some important differences. Path 2 is for everything else. All other sex discrimination complaints other than sex-based harassment in higher education involving student party is going to be under path 2. And so that's going to include all sex-based harassment complaints in K-12 schools, all complaints in K-12 schools, and then sex-based harassment complaints in both K-12 and higher education where only employees are involved. And this is a much more bare bones process with many fewer requirements. We're going to be able to get through a lot faster than under the current rules, which is great. So what does this process look like? Well, first of all, we still have to give notice. We still have to get notice of the complaint. So how does a educational institution get notice under the new rules? Well, you can still make a report. Anyone can make a report to the Title IX coordinator. That's going to be your obvious case. In K-12, it's still the case that notice to most employees will mean notice to the institution. But there is an exception for confidential employees. So in K-12, notice to any non-confidential employee must be reported to the Title IX coordinator. And so therefore, the knowledge of any non-confidential employee is imputed to the district. In all other institutions, all employees must either notify the Title IX coordinator or notify the reporting party of the Title IX coordinator's information and information about how to file a complaint. There's a lot of different paths that you get to this conclusion here in the rules. When you look at the rules, there's a whole thing for higher education of like, who has authority to implement discipline and, this, that, and other, and they must report to the Title IX coordinator, and confidential employees, they don't have to report to the Title IX coordinator. But ultimately, the rules say that all employees either notify the Title IX coordinator or notify the reporting party of the Title IX coordinator's information and information about how to file a complaint. So what this means is that we're going to need to document this, and this is tricky, and I'll dig into this a little bit more, and I know other people will too. But what I want the takeaway to be for higher education is that we've gone from a official with authority responsibility to every employee basically has a responsibility. Even a confidential employee who doesn't have to report to the Title IX coordinator still has responsibilities of things to tell the reporting party. So this is a sea change, and this is going to require a lot of good training, not just your, compliance network pumping out just a little blurb that says you need to do this, but reminders and other things to make sure that all employees understand that this may not require everyone to report it to the Title IX coordinator, but it essentially requires every employee to do something. And that is very, very new. The new process, it gives broader rights to who can file a complaint. So still a complainant and a parent, guardian, or legal representative of the complainant guardian, still a Title IX coordinator can initiate a complaint, but also in cases other than those involving sex-based harassment, any student or employee can file a complaint under Title IX under these new rules. And even if someone is not a student or employee, if they are participating in or attempting to participate in the education program or activity at the time of the alleged discrimination, they can file a complaint. So this is also a big change. Under the current rules, we just say only the complainant and their parent, guardian, or a Title IX coordinator. That's it. And the parent guardian even only comes into play if this person is a minor. So for higher education, it's very rare that it's anybody other than the complainant or the Title IX coordinator. But now that is being broadened, at least for cases not involving sexual harassment. So you might see this come into play where someone comes in and says, I think that the athletics program is inequitable in its treatment of female teams. Doesn't matter if that person is an athlete. If they are a student or employee, they can file that complaint, and you're going to need to use your Title IX process, that more bare bones path, luckily, to address that behavior. The new rules tweak what is required for the Title IX coordinator to do when they receive notice of a report or a complaint. You still have to offer and coordinate supportive measures for the complainant. The rules now specifically say that if the formal or informal grievance process has been initiated, that you must also coordinate supportive measures for the respondent. So that's a change, I think, from how some people interpret the 2020 rules. I know I've always said we should give supports to respondents because we just need to treat parties equally. But this makes it clear, and it makes it clear when you are required to do it. This says you must still continue to notify the complainant, or if that person is unknown, the reporting party of the formal and informal grievance processes. So the investigation and decision-making process, and then also the informal resolution process. That's not new either. The requirement that you tell the reporting party is kind of different, but it's not such a huge deal. So remember, this can be done by providing someone a physical copy of the grievance procedures or policies. So it'll be easy to do, but you have to continue doing it. The real tricky language in this part of the rule that gets me is this language that it says that regardless of whether a complaint is initiated, that the educational institution must take other appropriate, prompt, and effective steps to ensure that sex discrimination does not continue or recur within the recipient's education program or activity. This, I think, is just an effort to codify the idea that even if someone doesn't file a complaint, you still must take whatever steps you can outside of investigating to address that behavior. But the language is a little tricky, and I think it's going to require some, pretty deep thinking about what to do in a case where you receive notice of conduct that, if substantiated, would violate Title IX, but there's not a complaint initiated for one reason or another. So be aware of that new language and know that you're going to need to be thinking that through. There is still a requirement that you provide a notice of allegations to parties. In all cases, it has to include the grievance procedures, including informal resolution procedures, allegations with the same kinds of sufficient details that we've become used to, the names of people involved if they're known, the dates, the basic description of what is alleged to have happened, and a statement that retaliation is prohibited, and a statement of the right to review evidence, or a summary or report of the evidence, which we'll talk about in a minute. This is pretty bare bones. So this is much less than what's in our current notice. Our current notice is really long, but this is much less. So that's good. If it's a case that is in post-secondary education, sex-based harassment involving a student, you must do more. The notice has to be in writing in that case. It doesn't have to be in writing for all other cases. Although I'm going to probably be telling you do it in writing, because it's just, as a former OCR investigator, it's really hard to prove when something is done verbally. At least, follow up in writing. But anyway, it doesn't have to be in writing unless it's a post-secondary education sex-based harassment case involving a student. You also have to include some other stuff that was in our notice of allegations under the current rules, like presumption of non-responsibility, your ability to present evidence, the right to have an advisor is still required in those cases, but not in the others. And the one thing that's a little new with the notice of allegations is that in higher education sex-based harassment cases involving a student, the institution can reasonably delay issuing the notice of allegations if it has legitimate concerns about safety. So that would allow us to hold off, for example, to allow law enforcement to come in and maybe arrest someone or take a person into custody if we think that there is a serious legitimate concern about safety. The updated rules include dismissals. They continue to include dismissals for many of the same bases, although not all of them. And the big change is that the rules say that you may, but not must, dismiss. Now, there's not any language here about like deliberate indifference when making this decision. It doesn't say like you can only dismiss if it's not deliberately indifferent to do so, but we might need to read that into it. So just something to keep in mind. We need to think through this more as to what does it mean we may, but we not must, because the options here are if you're unable to identify the respondent, if the respondent isn't participating in a program or activity and is not employed, if the complainant voluntarily withdraws and without the complainant's allegations, there are insufficient allegations of sex discrimination under Title IX. And then if the conduct alleged, even if proven, would not be sex discrimination under Title IX. Note that notice to where the complainant withdraws has to be in writing if it's a post-secondary education sex-based harassment complaint involving a student. So why does this may not must thing matter? Well, what if you get a complaint that is conduct alleged, even if proven, would not be sex discrimination under Title IX? Is there ever a circumstance where we would need to proceed using the Title IX process to address that? I think not. But again, I want to, sit with this a little bit longer and read the preamble and really dig in and make sure to understand that before thinking through what it means. Some big changes for dismissals is that you do have to notify the parties who know of the complaint at the time that it's dismissed of the dismissal and appeal right. That's nice. We don't have to send out the notice of allegations, I guess, initially, and if we're going to dismiss, which is good. And then we don't have to notify the respondent. So that's a good change. The dismissal must be in writing, as I said, if it's a post-secondary sex-based harassment case involving students. And then there's that language I mentioned earlier about both of those things I mentioned earlier that are a little weird. You must at minimum offer supportive measures to the complainant as appropriate and to the respondent in certain cases. Oh, again, if somebody comes in and they say, I want to file a Title IX complaint because I'm being discriminated against based on race, and I say, I'm dismissing that because it doesn't fall under Title IX, am I now required to give supportive measures as I would under Title IX to the respondent? This is a good reason to think about consolidating and not having a bunch of different policies anymore, and really just considering, can we use this Title IX process for other types of civil rights violations? Because then it doesn't create this weird situation where, you have this whole robust process for Title IX, and now am I supposed to use it even if someone makes a complaint and it turns out that it doesn't implicate Title IX? You also must, even if you dismiss, take other appropriate, prompt, and effective steps to ensure that sex discrimination does not continue or recur. So that is, again, getting to that language of what I'm reading it as is you've got to take any steps you can short of investigation. Maybe you're going to do training for a cohort of students or, things like that, even if you don't have a complaint. There's a lot of process information in these rules, but a lot of it is going to look really familiar. You have to treat parties equally. Okay, great. We've been doing that. No conflicts of interest or bias. Okay. Presumption of non-responsibility. Okay, we do that. Reasonably prompt timeframes. They've given us some major stages that I think we weren't doing before. I think most of us just say like 60 days for the investigation, but now they want us to be a little more specific. Objective evaluation of relevant and otherwise not permissible evidence. They've changed the lingo there a little, but it really hasn't changed much substantively, because the exclusion of privilege, medical, and rape shield evidence with some exception looks almost exactly the same. And the things that are new in the process that applies to all cases are that you can use a single investigator decision maker model, including your Title IX coordinator can do that. That's big for small institutions. Also, a big change is the reasonable steps to protect privacy. The rules for the first time recognize our right to potentially put in place limits on parties about sharing information that they learned during the Title IX process. Isn't that great? For those of us in institutions, we know that this gives us so much heartburn, that we think that people are going to be out there sharing information that they learn because we couldn't put in place any kind of gag rule. Now, we still can't keep people from doing what they need to do to defend themselves or to make their case, file lawsuits, file external complaints. But if somebody's just going out and telling other people in the education environment about what they've learned during the process, that we can address now. And then to make clear which procedures apply to which complaints. That's going to be a big deal because I think I've got it down, but it's going to take us a long time to even get it down ourselves. But we need to make sure that with all these different paths and different options we can choose, we can have a hearing in some cases, but not others. Our policies and procedures have to be very clear about which procedures apply to which complaints so that a respondent can know what they must comply with. There are some new and some old investigation requirements. Some things that we've become used to. The burden has to be on the educational institution. There has to be equal opportunity to present fact, witnesses, and evidence. You have to review all evidence to determine what is relevant and permissible. Now, big change for the investigation. The rules say that we have to give equal opportunity to the parties to review and respond to an accurate description of the relevant and otherwise not impermissible evidence, or if it's a post-secondary education sex-based harassment complaint involving a student, an investigation report summarizing the evidence, summarizing the relevant and not otherwise impermissible evidence. And then if someone requests to review the underlying evidence, they can, but they have to request it. Now, you could choose to give it all to them initially, but I assume most of us are going to choose not to because it requires a lot more work on our part to prepare that evidence. But also notice directly related evidence is gone. It's gone. We're dealing with relevant and not otherwise impermissible evidence. This is great because it means that we don't have to go through this misery of when we get all of this evidence that, it might not be relevant, but it is directly related. Or the worst nightmare under the current rules is you get something that's excluded from relevance, like rape shield information, but technically still directly related. And so am I supposed to give that to the other side? This cleans this up quite a bit, and I'm very happy with it. No more directly related evidence. And also this idea that I can just share either an accurate description of the relevant and permissible evidence, or in the case of post-secondary institutions in sex-based harassment complaints involving students, an investigation report summarizing the evidence. And then it's up to the party if they want to request to see all of the underlying evidence. That is going to be big. It's going to move things along. There is no more 10-day review period. It is out. All you have to do is give a reasonable opportunity to respond, and it's just one. So this is going to move things along a lot more quickly, even in post-secondary education sex-based harassment cases involving students. There are some additional investigation requirements for those post-secondary cases with sex-based harassment involving a student. Those look very similar to what we're dealing with today, and they're still fewer than what we're dealing with today. You have to give written notices of meetings or proceedings with sufficient time to prepare. You must allow an advisor. You can put limits on the advisor, just like we're doing now. There is in here language that says essentially that you have to give equal opportunities, if any, to the parties to have a support person present with them. So someone other than an advisor. We'll sometimes see non-minor students want to have both their advisor and their parent there. And this is just codifying what I think we've all been doing all along, which is if you're going to allow one side to have that, you got to allow everybody to have it. Reasonable extensions of timeframes are still allowed with written notice. If there is a live hearing, you have to have the evidence available. That's something that exists now. So these are all similar to what we're dealing with now, less than what we're dealing with now, and only apply in cases involving post-secondary education, sex-based harassment, and a student. What about decision-making? Well, there is still a decision-making process that involves questioning, but it is much more limited than what we see under the current rules. So in all cases, the decision maker has to ask questions of parties and witnesses to assess credibility and other things. But it can be during the investigation if you're using a single investigator decision maker model. And for example, it's a K-12 case. So that's really, really big. For post-secondary sex-based harassment complaints involving a student, you have options. You can offer a hearing. And you're going to hear from lots of smart people that for many in higher education, you're going to need to offer a hearing because if you're a public institution and credibility is an issue, which it usually is in these cases, the courts have really moved in that direction. But they don't go so far as to necessarily say that an advisor has to do the questioning. And so the rules give you the choice to have an advisor do the questioning, in which case you have to provide an advisor if someone doesn't have one, and you have to have the decision maker decide if it's for some reason not relevant or permissible. It does not require any longer that you do that horrible you can answer during the hearing. So that's awesome. But regardless, I mean, this level 1 here, advisor questioning, I mean, if you can get rid of it, it's going to be great. It's going to be no more advisors that you have to provide to the parties, no more rulings in the moment, no more questioning by an advisor of the party, which can be really stressful for them. What's the alternative? Well, you could have the decision maker ask the questions. You just have to let the party submit questions beforehand. That's huge. The great news about this is that this is going to change hearings. I think it's going to make hearings a lot more humane. But you need to look very closely at what, for higher education, what do you do for other cases? What does your dean of students do? Because if they are allowing advisors to be there and ask questions, for example, then you're gonna have a hard time providing less process for more serious cases. So work with your dean of students on that, but this is amazing. This is such good news. You can also in higher education just have individual meetings. You don't even have to have a hearing. So for private institutions, for institutions in a jurisdiction where it's not so clear that you need to offer a hearing, this is a really good thing because hearings would be gone. You would be required to provide either a transcript or a recording of those individual meetings so that you can give the opportunity to ask both questions before from the other party, and they can ask follow-up questions after. We still have to end the process with a written determination. And we're still going to be using the preponderance of the evidence standard, I think, in most cases. There is the allowance that if you use clear and convincing in all comparable cases, you can use that. But I don't think most people are doing that. And maybe people will change, but you would have to change everything across the board in your institution if you were going to do that. Now, the big difference is that the decision, the report, the written determination, that big bulky thing with all those requirements, it's gone. For most cases, you just have to provide written notice of the outcome, including what was your determination about whether or not sex-based discrimination occurred or did not occur? What is your rationale? And what appeal rights are there, if any? That's it. This is so much less work than the current written determination. For those post-secondary education sex-based harassment complaints involving a student, you got to do a little bit more, but it's still nothing like what we're currently required to do. You have to include a description of the alleged sex-based harassment, information about relevant policies and procedures. You have to evaluate the evidence and make a determination of whether sex-based harassment occurs. So they're going to want to see a little bit more of that evaluation as opposed to just the rationale for the decision. And you have to include disciplinary sanctions that are going to be imposed and also whether remedies for the complainant or others will be provided. That I'm still going to be recommending that you not say what those remedies necessarily are if it's for a complainant, because that should be private. But you're going to say that it is going to be provided if it is. And then appeal procedures. And for these PSE, post-secondary education, sex-based harassment complaints involving a student, you must offer an appeal. You have to give an appeal, and it's on the same basis that we're used to under the current rules. The same things, new evidence that wasn't available before, procedural regularity, bias, or conflict of interest. It's pretty much the same thing that we're used to. So for those post-secondary education sex-based harassment complaints involving a student, you have to give notice of the appeal of the right to submit written responses and the appeal decision in writing. Now, you still have to give all that stuff in all the other cases too, but you don't have to give it in writing, which is really nice. For all other complaints, you are required to offer an appeal process that at minimum is the same as offered in all other comparable proceedings. So you're probably going to be offering an appeal, but technically it's not required unless you do so for other comparable cases. It is permissible for anyone to offer appeals on other bases, but it must do so equally. And it is required that you use a different appellate decision. All right, guys, we have covered so much, but that's it for today. What I do want to leave you with is the prophecy, okay? This conversation has just scratched the surface of the 2024 Title IX rule. We're going to need to talk a lot more. You may want to go back and watch this like 5 times for it to actually sink in. This is a lot. We need to talk about preventative and proactive measures. We need to talk about pregnant parenting requirements, informal resolution training, and more. So we're going to do that, but we're going to take it one step at a time. It's going to be a cruel summer. You may remember that my colleagues, Holly McIntosh and Rebecca Bailey at Thompson Horton and I, before I left the firm, we did a cruel summer webinar. I'm trying not to read too much into the fact that the Department of Education released the rules on the same day as the Taylor Swift album because we did that training. But yeah, I know that's delusional, but regardless, it is going to be a cruel summer, but we're going to get through it together. We have so much support, and I'm here to support you. Even though I'm not available nearly as much as I was before, I am still so thrilled to have the ability to collaborate with people in this field so that I can do my job better in my full-time job. So please always feel free to reach out to me with any questions. Thank you so much for joining, and I hope that this has been helpful.